Good morning. Welcome to this 39 Essex seminar on liquidated damages. My name is Paul Darling. I'm a barrister at 39 Essex Chambers, and I'm chairing the second of the two webinars given by 39 Essex Chambers on the topical subject of liquidated damages. There are two reasons for that. First is that I have a long history of conducting cases about liquidated damages. Richard Wilmot-Smith, who chaired the session yesterday, talked about his involvement in a case called Rapid Building in Ealing. That was an important case. I, around the same time, argued a case called Temlock and Errol in the Court of Appeal on liquidated damages being £0. But the reason I'm chairing today rather than speaking is that I was counsel in Triple Point, for Triple Point, and you'll hear a lot about that, and perhaps I can say a few words about that. Though, of course, obviously the result was not the one for which I argued. Very lucky to have with us today 6 members of 39 Essex Chambers who are part of the construction and commercial team. They specialise both in construction and commercial work, and they bring to their perspective of this the benefits both of being construction lawyers and commercial lawyers at the same time. Now, we're going to take the order. We're going to start off, and happily the order works very nicely. Nicholas Higgs is currently appearing in arbitration, and therefore will be giving his short talk to each of you, to us, and then moving on. Happily, his subject matter segues in very nicely to yesterday's programme, and he's going to be talking to us about what are the implications of McDessie when negotiating a liquidated damages clause. What due diligence should you carry out to make the quantum in such a clause penalty-proof when negotiating? Those of you who joined us yesterday will know that there was some talk about that yesterday. Nicholas is going to introduce that topic for us as we then go on through our liquidated damages provisions. The chat is open, the Q&A is open. I will try, if I can, to pick up the questions if they come in and put them, and we'll see how we go. Each speaker is going to be about 10 minutes, and that should give us some time for some discussion. So, Nicholas, over to you.
Great. Good morning. Thank you, Paul. Good morning, good afternoon, wherever you are in the world. It's my task to kick us off this morning, asking how are you going to penalty-proof your LD clauses? So I've got 10 minutes to do it, and I'm going to really seek to answer 4 questions. First of all, is a genuine pre-estimate of loss still relevant post-McDessie? Secondly, is there actually any changes we need to make after McDessie? Does McDessie give us some wider latitude or discretion in how we're drafting our clauses? And finally, are there some alternative means that we could be considering to obtain performance from contractors? So the first question, genuine pre-estimate of loss. It's a phrase that's been in the construction law lexicon for over 100 years. And even post-McDessie, I'd suggest it's going to take a little while for construction lawyers and judges to let go of it. Recently, there have been 2 Court of Appeal cases post-McDessie. In 2018, Lord Justice Coulson was sitting in North Midland Building and Sidon Homes. And in that, he said, in rejecting one of the grounds of appeal, the first reason for rejecting the ground of appeal is that, in the absence of any suggestion of a penalty, the liquidated damages provision must be taken to be a valid and genuine pre-estimate of anticipated losses caused by the delay. And then in 2019, in Triple Point in the Court of Appeal, which we're going to hear some more of later, Sir Rupert Jackson, there sitting in the Court of Appeal, said, although the contractual formula is not perfect, it is a genuine pre-estimate of the losses likely to flow from the delay. So even post-McDessie, the language of genuine pre-estimate of loss still seems to be part of the consideration of judges. Although I think that is changing slightly. So there was a case this year, Eco World and Dobler, Mrs. Justice O'Farrell sitting in the TCC, there made reference to the tests that as they were set out in McDessie. That is, the liquidated damages provision is not extravagant, exorbitant, or unconscionable. It's a secondary obligation imposing a detriment on the contractor, which is proportionate to the legitimate interest of the employer enforcing the primary obligation to complete on time. So we've had 100 years of genuine pre-estimate of loss. It's going to take a while to change entirely over to McDessie. But I think the idea of a genuine pre-estimate of loss still has validity. If that is the way in which you have estimated what the liquidated damages should be, it is very unlikely that that is then going to be found to be extravagant, exorbitant, or unconscionable. So I suggest the test in McDessie widens what is going to be permitted as not a penalty, but the core of a genuine pre-estimate of loss is normally always going to be found to be within the test set out in McDessie. And when we're talking about a genuine pre-estimate of loss, it is important to remember that this doesn't mean an honest estimate. And that's what Lord Justice Buxton said in Murray and Leisure Play in 2005 in the Court of Appeal. So this was pre-McDessie. And there the court was very much concerned with this dichotomy between either it's a genuine pre-estimate of loss or it's a penalty, and there's no room in between. And that's really what the Supreme Court said was wrong in the consideration of post-Donlock cases. There isn't this dichotomy, and that was incorrect. But it doesn't mean that a genuine pre-estimate of loss isn't a valid test. So genuine doesn't mean honest. It just means that it doesn't also mean that you can be dishonest in calculating your liquidated damages. But it does mean that there's been some attempt. Real, I think, is a better way to put it. Genuine means there is a real pre-estimate of loss. There are some real losses that are going to flow if the contractor is late for the employer. So that means I suggest that the standard means that we've always used to estimate our liquidated damages, such as loss of rental income on a commercial property, delayed power production on a power production facility, or even the extended site supervision, site establishment costs that the employer might have if the contractor is late completing. All of those are normally still going to fall within the McDessie test. And there's going to be no realistic prospect of suggesting that estimates based on those kind of measures are going to fall to be a penalty. But as with everything, and this was drilled into me when I used to work for Arup, records. If there's a contemporaneous document that sets out the calculation of the liquidated damages that's made before entering into the contract, that's going to be one of the best answers to any assertion from the contractor that these liquidated damages are a penalty. If it can be shown that there was a genuine, inverted commas, attempt to estimate what the damages flowing from late completion were before entering into the contract, and there's a real basis for that, then it's going to be very, very difficult for any contractor to argue that that's a penalty. And I think that's reflected in reality in the cases we've seen that where that's been argued successfully. It's very unusual for particularly in a construction contract for a liquidated damages provision to be found to be penal. So the third question was, is there now a wider discretion post McDessie? And I think the answer to that is yes, there is. There's wider discretion or latitude in what could be considered valid estimation of liquidated damages. Because we've got the four tests, really. Is it a secondary obligation? It will always be a secondary obligation in a standard form construction contract. You might have done some bespoke drafting that doesn't meet that test, but normally always we're going to have a secondary obligation enforcing a primary obligation. Is there a legitimate interest to be protected? It would be a very unusual situation where there is not a legitimate interest in the employer in having their asset completed on time. Is it proportionate to protect that interest with the liquidated damages? And is the estimation not extravagant, exorbitant, or unconscionable? And in almost every situation, particularly in construction, it's going to be possible to answer those questions with a yes. So that test is going to be met. And it does, I think, mean that there's some wider scope for how liquidated damages can be estimated. So things such as valuing the social value of infrastructure for a public sector client, or considering what would be a shadow tolling revenue from a road. Things like that could go into the mix of how you estimate what the LDs should be. And as a member of the ICE and a former employee of Arup, I hesitate to recommend this report, but it's actually very good. It's by Jacobs, published by the RICS, and it's called Measuring Social Value in Infrastructure Projects, Lessons from the Public Sector, which was published in September 2020. And so that's a really good resource for having some ideas about how monetary value can be placed upon the social value, particularly for public sector infrastructure projects. But we've got to remember not to get greedy. Blue Sky Solutions and Caring Limited, which was 2021 case earlier this year in Commercial Court in Manchester. The liquidated damages were over 8 times the loss for cancelling some mobile phone contracts, and that was found to be disproportionate and unconscionable as a charge for cancellation. So the tests of McDessie, I think, do give us a slightly wider latitude in estimating the liquidated damages when we're drafting those clauses. The final point is, actually, are there some alternative means that can be being used in contractual in contracts for obtaining performance? If we're getting to LDs, from the employer's point of view, that is a far from ideal situation. That means their asset is late. It is much better to have some prevention measures rather than cure at the end of the day. So are there measures that you could be considering in drafting contracts which are going to encourage performance along the way rather than getting to the point at which, well, it's late and here's some LDs? An example that we used on the Queensferry crossing in Scotland was it was a quality price tender. And the quality marks were then converted into an equivalent value in monetary terms on the basis of the total contract price and converted into KPIs, which then had to be earned by the contractor on various measures, including progress and progress reporting. So that kind of incentive mechanism is perhaps something that can be used during the concurrency of the contract to encourage performance as you're going along, particularly bonuses for early completion. Is it better to incentivize the contractor to be completing early rather than penalize them for completing late? And things such as a contract teach-in for the client, so that those operating the contract actually understand what's being required under the contract, can be absolutely invaluable and a much better means, rather than enforcing the contract at the end of the day when it's all late. Getting everybody on board and getting the contract working while it's concurrent is a much better solution. So that's a very brief 10 minutes, almost exactly, on penalty proofing your
I think it was 11. I don't think you'd used any of the incentivization measures that you recommended to us so clearly. Thank you very much, Anita. I'm not going to pick any questions up now, but I am going to pick up your last point so that perhaps the next 2 speakers and the audience might consider it. Liquidated damages appear, if one looks at Triple Point, which we're going to hear about later, and North British and all the other cases that have been referred to, looks very much as the liquidated damages, having been previously treated by the courts with some suspicion, have now almost become a national treasure. The whole mood has changed. And when we get to talk about Triple Point, we'll see that in acute terms. But I suspect that that's because the law has modified the way it has. So thank you very much indeed for your contribution. We hope your cross-examination or whatever it is goes terribly well. Do stay as long as you're able to. But if you're not, anyone has any questions for you, I'm sure we'll find a way of getting them to you so you could answer them. So thank you very much indeed. We now turn to Ruth Keating, who is going to talk to us about whether a party can apply to the courts for an adjustment of the liquidated damages upwards or downwards. Obviously, that'll have in mind Nicholas's ringing suggestion of alternative methods of enforcing contracts. But Ruth, perhaps you could now join us to deal with the adjustment of liquidated damages.
That's great. Thanks, Paul. And I'll certainly make sure to pick up on your language of penalty clauses being a national treasure now and try deal with that as well. So looking at the question of whether a party can apply to the court for an adjustment of a liquidated damages clause, we've heard from the other panelists, including Nick today and including yesterday as well, that there are really specific characteristics of liquidated damages clause. So they relate to specific breaches. We've heard that they quite commonly relate to delayed completion. And as a matter of construction, they operate as an exclusive remedy in respect of those breaches. And so I think it's fair to say that looking at those core aims, what emerges as a core theme is that liquidated damages clauses, they're aimed at increasing certainty between the parties. And they're also aimed at cutting through what can be an extremely cost intensive exercise and a very time intensive exercise as well. Now, having said all that and espousing the virtues of liquidated damages clauses, there'll no doubt be many people listening today. There may be some of the panelists. We'll certainly all have clients who years down the road suddenly look at their contract almost for the first time when there's a problem emerging on the horizon and realize that they really don't like the figure in the liquidated damages clause that they've signed up to. They're no longer happy with it. And the next question that we'll all be asked then is, can I apply to the court for an adjustment of that liquidated damages clause? And certainly taking the first point that I'll cover, looking at the UK, the answer to that question is that many of the core themes of liquidated damages clauses are effectively undermined almost entirely if parties can simply go to the court and request an adjustment of the liquidated damages amount that they've previously agreed to. And we see that reflected in the case law. I think it's fair to say we see even more of a trend of that reflected in the case law, and certainly the comments of the Supreme Court. And it's an issue which you can see lingering in the background of McDessie. So looking at paragraph 35 of that judgment, what the court was at pains to point out in a high level general principle was that in a negotiated contract between parties that are properly advised, and this is the words of the Supreme Court, the strong initial presumption must be that the parties themselves are the best judges of what is legitimate in a provision dealing with the consequences of breach. And they go on to elaborate that. They cite Lord Woolf many times in the judgment, and he certainly was popular in McDessie. But one of the quotes that they bring out from Lord Woolf was that they say he was rightly at pains to point out that any assessment of penalty clauses didn't mean that the courts could thereby adopt some broader discretionary approach. And I think it's fair to say that certainly looking from a UK perspective in terms of adjustments, that's at the real heart of these adjustments or assessments that the courts are making. They're very slow to intervene in terms of what has already been agreed between the parties, not least because they are generally in the best position to know what that liquidated damages clause should award. And all of that is to say that certainly in the UK tradition, it would fly in the face of the core aims of liquidated damages if applications could simply and routinely be made to the court to modify liquidated damages clauses. And again, we see that reiterated in McDessie just earlier on in the judgment of paragraph 32. And what that says is the court has to bear in mind that what the parties have agreed to should normally be upheld. And they say that's not least because any other approach will lead to undesirable uncertainty. And they say that's especially in the case of commercial contracts. So it's something which we've had said from the Supreme Court at the highest level. And so the message certainly in the UK is that the courts are slow to step in and disturb the agreement which has been reached by the parties where possible. Now, of course, this webinar is very much focused on England and Wales naturally, but looking, of course, at construction and the world of international arbitration, the question that then arises is what about other jurisdictions? If we're dealing with disputes in other countries, are those courts going to adopt the same deferential approach that the UK courts have? And the answer is very much that will depend on the jurisdiction that the dispute is in. And it can very much change depending on the national laws of that country. And it's important to be aware of that divergence. So, for example, as a matter of Omani, Jordanian and UAE law, a party can apply to the court or arbitral tribunal to adjust contractually agreed compensatory arrangements. And what that then means that is in a very different way to UK courts, those courts will then look at the loss and see how it can be equated with the actual damage or harm suffered. So I think that's picking up on some of the points Nick made in terms of his time at Arup and saying records, but there's a different point in the process, certainly in other jurisdictions, where that process becomes relevant. It might also be complicated by the domestic legal structure in other countries, and it can be much more complicated for that reason. And so other jurisdictions can sometimes have a specific statutory provision which says that the courts have a power on the application by either party to award compensation equal to actual loss. And there are examples of that in other jurisdictions, such as Lebanon and China. Now, the main point, of course, is that no lawyer is expected to know the full world map and how each of them deal with liquidated damages differently. But the point that it is mindful to be aware is that often lawyers can sometimes have, depending on their jurisdiction, all of these core aims in mind. And certainly as lawyers of England and Wales, we think some of the reasons why we have this deference to liquidated damages clauses are self-evident. And certainly in other jurisdictions, they've taken a different approach, which is very important to be mindful of. Picking up on the final point from all that is that can sound quite negative in terms of making an adjustment to liquidated damages clauses unless you're in another jurisdiction. There are routes that we see in the case law where parties are often trying to get at the same result by different means. One of the points there, of course, is the national treasure of penalty clauses and the route that parties might take to challenge liquidated damages in that way. Looking at the 5, I think, core themes that we see emerging from the case law and the way in which parties are trying to challenge these liquidated damages clause in the absence of having an easy route of adjustment. The first is that parties might often try to argue that the breach that's at the heart of the dispute is a different breach in essence to the breach referred to in the liquidated damages clause. And in that way, they might try bat it out of the way and say it's simply not within scope. That's one way the parties may try get around the liquidated damages clause. A second way that we see in the case law, forever popular, is that someone might try argue that a particular clause, in this case, liquidated damages clause, is invalid for void or void for uncertainty. Now, I think many of the panelists, certainly, and those listening, will know how difficult it is to launch a challenge like that, but certainly depending on the circumstances, one argument which a party might try make. The third, and again, it crops up in construction cases in particular, is that there may be a failure to comply with the condition precedent to activating the liquidated damages clause. And again, it's very important, depending on the facts of your case and potentially a trigger-happy party on the other side, to really look at whether the necessary contractual steps have been followed before you get into the territory of assessing whether the liquidated damages clause applies. The fourth, and again, this is something which often plagues certain construction projects, is that if the liquidated damages clause relates to a delay, a contractor might try argue the time has become at large. And again, it's another way of trying to bat away the liquidated damages clause and saying that the issue no longer arises or is within scope. And finally, of course, and we've had our advice from Nick on how to make our clauses bulletproof, but it will always be popular and will continue to be to try launch a challenge to a liquidated damages clause on the basis of it being a penalty. And again, that is something which you want to insulate yourself against, particularly if you're a party asserting a liquidated damages clause. So, Paul, that's just a quick run through of whether an adjustment can be made and how the approach differs in other jurisdictions as well.
2 points I might make, if I might. Firstly, your point about adjustment is obviously, if you can adjust, it's inconsistent with the concept of liquidated damages avoiding the proof of actual loss. The two don't fit together. Secondly, I'm interested by your eloquent run through the ways you can have a go at these sort of clauses. Taking a historical perspective on it, I think that 20 years ago, those sorts of arguments would have been thought to be even more substantial than they are now. And I think that there is a much greater willingness in the courts to enforce liquidated damages clauses. One of the great fascinations, of course, is that you never know whose benefit they are for. A lot of the trend of the authorities is that poor contractors being forced to pay liquidated damages, and therefore one shouldn't enforce the clause against them unless it's strictly complied with. However, if it's a very valuable limitation clause, as mine was in Temlock and Errol, where it was held to limit damages completely, or it's a low amount, then the contractor may very well be desperately trying to preserve the liquidated damages clause, and the employer is of course then trying desperately to get around it. Now, that distinction was one that I failed miserably to persuade the Supreme Court to get interested in, but I do think that the cases have to be seen through the prism of which party it is that is trying to get round it. Now, the words "get round it" come very easily when one hears the word estoppel, and we're now going to hear from another member of 39 Essex Chambers, Philip Kuhn, who is going to talk about the lessons for drafters of commercial and construction contracts and whether a contractual estoppel works and where the wriggle room is. So I think that's picking up what Ruth said and moving forward with it. So Philippe, over to you. Thank you very much.
Thank you, Paul. I was also going to cover a few more general lessons. So I think I'll start with the specific point on estoppel, and then I think we've covered some of them already, and I don't want to repeat, but I'll take it in that order. Starting with the contractual estoppel point, it's fair to say that this is really quite an obscure, I wouldn't call it a doctrine, but a concept in this area. And when in preparing for this webinar, I think I had to give real thought to where a contractual estoppel might even come in this context. And helpfully, the point was touched on in a very recent case in the commercial court, Heritage Travel and Tourism Limited and Windhorst. It was quite a complex dispute, ultimately turning on the enforceability and the terms of a settlement, which in turn was breached. And that's how the liquidated damages arguments came up. There were various clauses and there were different arguments, including primarily that one of them was a penalty clause. But the one that I want to focus on and where this contractual estoppel argument comes in is that as part of the so-called June settlement considered in that judgment, certain events would trigger the payment of a daily lump sum of about 140,000 euros. And to give you a bit of flavor, the overall settlement, I think principal amount was in the region of 50 or 60 million euros. And then there were various additions, which this is one of. And the clause, and I think my friend Ruth will assist me with bringing up the relevant clause. You'll see that the opening words, as I described, deal with this settlement and give you a bit of the context. And then it says, as you can see as well, an amount equal to 69 million plus this daily lump sum amount, which I've just mentioned. And then the interesting words, which are in bold, are these: the daily lump sum payment has been negotiated and agreed between the parties as being a fair reflection of the values to the claimants of ensuring compliance by the obligers with the terms of this settlement agreement. And I think we can take that down now. Thank you very much, Ruth. And the interesting point is that Richard Salter QC, who was sitting as a Deputy High Court judge in this case, had found that the penalty doctrine, as was established and really clarified in McDessie and established in earlier cases, is only triggered where there's a payment on breach. And that's what he considered primarily. If you want to have a look at that, that's paragraphs 89 to 92. He then considered, and on the facts, he concluded that for that reason, it wasn't really appropriate to apply the penalty doctrine to this clause in any meaningful way. It's quite an involved analysis, turning on the wording and the overall context. I won't go into that. But where this contractual estoppel point comes in is in his consideration of disproportionality. So the question of whether it's extravagant, unconscionable, / not proportionate to a legitimate interest, the McDessie tests which we've described. He then considered, assuming the penalty doctrine had been engaged, whether this wording that I've just shown you should sway the court one way or another. And his analysis, and I really agree with it, although I'll give some additional reasons beyond those that he gave. And just to quote, at paragraph 97, he says, "I'm not attracted by the suggestion that the recital at the end of clause 3.1b determines the issue of disproportion in the claimant's favor under the doctrine of contractual estoppel. He says, the point wasn't fully argued, and I think we shouldn't treat this like a court of appeal or Supreme Court authority, and judge is very clear about that. This was a decision on a summary judgment application rather than at trial, which is another reason why he was tentative about it. But he said, and this is the reason he gave, such an approach would be inconsistent with the public policy basis of the penalty doctrine. And that's quite an interesting point. So the theoretical framework really here is that liquidated damages clauses are a departure from the principle of having to plead and prove your losses for breach. And as we've discussed, they are a way to avoid disputes about quantification. And as Paul said a moment ago, picking up on the question of upwards and downwards adjustments, it would be inconsistent to engage in that sort of exercise. Either they bite or they don't bite. And really what Richard Salter QC is saying there is simply by adding what might end up being pro forma words, that this has been specifically considered and everyone's happy with it, if that is enough to engage the doctrine of contractual estoppel and mean that you can't run a penalty argument on an objective analysis of whether, assuming the sum was payable on breach, it was disproportionate, would be ousting the court's jurisdiction. And we see that sort of argument in other contexts as well. For example, the restraint of trade doctrine, which applies in employment contracts and business sale contracts in particular, equally is a public policy doctrine, not dissimilar, although differently formulated, but in theoretical ways similar to the penalty doctrine. And I would suggest that the same rationale is seen in those cases. It's very common, especially in employment contracts, to have this sort of pro forma language of everyone, the employee happily agrees to all of these restrictions, you can't work anywhere else for 2 years. And the courts have, by and large, just ignored that sort of thing. And I think the same argument would apply here by simply adding in a commercial contract or a construction contract some sort of recital, whether it's at the beginning of the contract in a preamble, as is quite common, or as in this clause 3.1b in the clause itself, shouldn't sway you one way or the other.
Philippe, can I just feed in a question that's come in from Bajit Rajani about nomenclature the other way round? How important now, if at all, is nomenclature, for example, if you describe what was in truth a liquidated damages clause as a penalty? And I think the same point you're making would apply in the other direction, that it's the substance of the clause rather than the description.
Absolutely, and that's actually dealt with more fully than this contractual estoppel point in a lot of the cases. I mean, from the top of my head, I think in Dunlop itself, which is, I think, 1915, the point was made that it's an inquiry of substance over form, and a lot of the subsequent cases, including Magdessine, looking at the case law, have made that point. And it's not uncommon, actually, to see parties accidentally describing something as penal, especially where you're perhaps dealing with international parties that are approaching. I've seen it a lot in Eastern European contracts, for example, where on default interest, sometimes it's described as penal because that's what they're comfortable with in their jurisdiction. And assuming it was an English law contract, I agree with you, Paul, that it wouldn't sway a court one way or the other. It's a question of, was it actually penal, not how has it been described?
Yeah. Thank you very much. Do continue.
Can I have a sense of, on the wider lessons, have I got about 2-3 minutes?
4.
Okay, excellent. So the first one, and I think we've covered this already, is since Magdessine, you shouldn't depend on the penalty doctrine as your escape route. So take real care in drafting these clauses and think carefully about the amounts, and especially if you're likely to be well, it cuts both ways. Either the paying or the receiving party, one way or the other, you might want to build in an additional buffer or be extra careful, because you won't be able, in most cases, to depend on the courts stepping in to rescue you. The second point is this breach argument is really interesting, and it takes me back to the heritage travel case. If you can make an argument that the clause is actually a conditional primary obligation or purely a primary obligation, that is a way of getting around the penalty doctrine altogether. And the genesis of this is interesting. There was a 1980s case, I forget the name of the case, but Lord Roskill gave the judgment and made this as a sort of passing comment. It's a doctrine dependent on breach. And it's in McDessie that was put on much firmer footing, and is a very useful way. And interestingly, the English approach differs from the Australian approach on this point, where in a case called Andrews, decided just before McDessie by the High Court of Australia, they don't quite accept this strict dichotomy between primary and secondary obligations. So it's a quirk, really, of how the English law doctrine has developed, that there's this hard-edged distinction. And practically, where it comes in is you might be able, on a summary judgment application or preliminary issue basis, to argue that the doctrine isn't even engaged and we don't need to have a trial on questions of disproportionality, which is essentially what happened in heritage travel, where the judge was persuaded by that argument. And what I've described to you about the contractual estoppel was all obiter, because it didn't strictly arise. Then we've already covered, and I won't go through it again, this genuine pre-estimate of loss point. As Nick says, it's still there. It's not the test, but it's something that will be factored in. And really the other point which has come out in the question was substance over form, and context, understanding the relationship. McDessie is an interesting case because it was a very high value sale of an advertising business involving in total up to 150 million euros or so. And the court was very comfortable with saying these are sophisticated commercial parties and there isn't the same imbalance. The other appeal heard with McDessie, Parking Eye and Beavis, was quite different, because that was about a fairly large parking company and really consumers, and there were additional Consumer Rights Act arguments. So depending on the context, there's other arguments may be available to you, but in true commercial and construction contracts, the doctrine is now quite limited in practical reach. And I think with that, back to you, Paul.
Philippe, your timing is impeccable, because I was going to cut you off and start. So a couple of questions I wanted to try and deal with. First one, which came in while Nicholas was talking before he went off to start to cross-examine his witnesses, was about whether a genuine pre-estimate of loss, even though it made a glaring error, whether that would be upheld or not. Ruth, do you want to comment on that?
Well, I think again, Paul, you've probably made yourself in a bit of a difficult position with the hypothetical to get there. Again, it goes back to what Nick said about records and justifying the approach. It might be that by some kind of pure act of luck, the glaring error actually aligns with something you can justify, but you're going to find yourself in a difficult position. All of these things are always ideal, but what you want to be doing is have records which justify the amount that's reflected in the contract, and then years later you can simply show that and say, this is why this is the correct approach.
If there's a glaring error, it means you've got your work to do, but you can still do your work.
Exactly. Yeah, you just don't want to be in that position.
And the second category of question, I wanted, just picking up on what Philippe was just saying, but both of you may have a view. One of the other questions we were asked is how are take or pay clauses treated? And then another similar points made by another participant about incentivization, and if incentivization was to be paid back by the contractor should the contractor be late, would that be a penalty and generate the argument that it can't be applied? Now, I'd be interested just to have a couple of moments on the dividing line which Philippe was talking about between primary obligations and secondary obligations. Any thoughts about those two things?
I feel more comfortable dealing with the second one. I think in that scenario, it sounds like you may be entering the territory of a sort of conditional primary obligation rather than something payable on breach. It'll depend on exactly how it's worded. And in Magdesi itself, I think it was in the judgment of Lord Neuberger and Sumption, they made clear that there is where there's a sort of feeling on the part of the court that this is being used as a veneer to oust the application of the penalty doctrine. The court may still, in exceptional cases, look beyond that distinction. But where there's a sort of incentive structure and the parties hope that that would achieve their aim, I don't think a court would interfere with that. And if it happens to have give, I think in your example, Paul, the contractor less compensation than it was hoping for, I think the courts would just say, too bad, nobody forced you to agree to this.
Ruth, anything to add there?
Yeah, so it's an interesting question. I think I like the structure that Nick has laid out as well of incentivizing. I mean, in essence, contracts are all about incentivizing people to do things. But the flip side, of course, of an incentive is that if you fail to get the incentive, in some senses, you've lost something. I think that's going to be the thin dividing line. And that's a context-specific question, which Philip has outlined. At what point does the incentivized structure that you've set up suddenly become a burden, essentially, for the other party, or something which tips into a penalty clause? That's going to be a fact-specific exercise. But again, the courts are going to look beyond the veneer and the language, and they're going to look at what is the context between the parties and what are the actual factors which are at play between them.
Thank you very much indeed, all three of you. Nicholas no longer with us, but thank you to him and thank you to you two. We're now going to move on to triple point. And I'm, of course, having argued and lost it, feel queasy at this moment. We're going to have Alexander Burrell, who joined 39 Essex Chambers during lockdown, having been in Dubai. I've looked at his notes. He's got the points. I say that because whenever I hear the words triple point, I immediately default to trying to re-argue it. I should just say before he starts that if anyone after hearing his talk is interested in hearing the argument, it is still on the Supreme Court website. I tell you that without any modesty. There's one moment where Lord Leggett asked me a question, and I'm afraid I was under heavy fire, and my answer to him was, my lord, that's just plainly wrong. And you say you can't hear a silence on Zoom. Well, that's not right. You can hear that silence. But the argument is actually across all the various topics available and worth listening to. Alex is going to talk to us about the liquidated damages bit, and then Vivek is going to talk to us after that about some various other issues that also arose. Alex.
Thank you, Paul. Good morning or afternoon, wherever you are. So my segment, as Paul has said, is the question, are liquidated damages payable when work is never completed or accepted? And as stated, the leading case on this issue is a matter Paul knows a thing or two about, triple point and PTT. The first of the two main issues addressed by the Supreme Court in that judgment was, are liquidated damages payable when the contract has been terminated in circumstances where the contract does not specifically provide for the application of liquidated damages in termination. And that triple point is a very useful example of this issue. And so my segment will run through the background to triple point, the earlier court decisions, the Supreme Court's judgment on it, and then some possible implications for the future. So the base facts of triple point are relatively commonplace for construction disputes, albeit it wasn't a construction contract. Triple point agreed to provide PTT with software and software implementation services. Triple point were to be paid in successive payments by reference to these 18 stages or milestones. Triple point completed the first two of these some 149 days late. They were paid for that work, but they also demanded payment for other stages not yet completed. That demand was rejected. In response, triple point suspended the work, and in response, PTT terminated the contract. The liquidated damages clause, which was Article 5.3 of the contract, was not a standard form, but it's not dissimilar to liquidated damages clauses used in other contracts. And it provides, if the contractor fails to deliver work within the time specified, a contractor shall be liable to pay the penalty at the rate of 0.1% of undelivered work per day of delay. And now these are the key words: from the due date for delivery up to the date PTT accepts such work. So the issue is, as the contract was terminated before the work was accepted, does this clause and do LDs apply for that period? Now, on a literal reading of the clause in isolation, one can understand Triple Point's argument that liquidated damages do not apply. The argument goes, and I'm sure Paul will correct me if I'm wrong on this, but if the works were not accepted, the clause is not activated, as liquidated damages only apply for the delay from the date of delivery until acceptance. If there is no acceptance, then that is not a qualifying period of delay for liquidated damages. Now, on this issue, in the High Court, Jefford J. held that the liquidated damages applied up to the date of termination, and thereafter damages were at large. This was considered the orthodox analysis, which, of course, I'll return to in the Supreme Court's judgment. In the Court of Appeal, Sir Rupert Jackson gave the leading judgment in relation to this issue and conducted an extensive review of the authorities dealing with this point and divided the situations into three different categories. Category one is where liquidated damages do not apply if the contract is terminated. In establishing this category, Sir Rupert Jackson relied quite heavily on a Scottish case in the House of Lords, British Glanstoff Manufacturing and General Accident Fire and Life Assurance Corporation. Category two is where liquidated damages apply up to termination and not thereafter. And category three is where liquidated damages apply all the way up until completion by the replacement contractor, so even after termination. The Court of Appeal held that Triple Point was a category one case, the effect being that liquidated damages did not apply, damages were at large. The Supreme Court made two findings in relation to what the Court of Appeal had made determinations on. So they found the Court of Appeal had made two determinations in relation to this issue, or two key determinations. The first is that the wording of the liquidated damages clause, Article 5.3, could be so close to the wording in Glanstoff that Glanstoff was effectively binding as a precedent. And the second is that it should not be assumed that the liquidated damages clause, or that any liquidated damages clause, had any operation beyond the precise event for which it expressly provided. Now, the Supreme Court did not agree with the first determination that they found the Court of Appeal came to, finding that Glanstoff, rather than laying down any principle, was the case on the interpretation of a single contract. Lady Arden, who gave the leading judgment in the Supreme Court, further gave guidance on the limited circumstances when precedents concerning the interpretation of contracts could be binding. And those precedents deal with, quote, market-accepted wording or clauses from some standard form recognized in the industry. Indeed, hammering on this point, Lady Arden confirmed as follows: with those exceptions, in general, the decision of one case as to the meaning and effect of a clause cannot be binding as to the meaning and effect of even a similar clause in another case. Now we'll return to that in terms of future implications. But in respect of the second Court of Appeal determination, namely that it should not be assumed that an LD clause had any operation beyond the precise event it expressly provides for, again, the Supreme Court also did not agree. Again, Lady Arden, giving the leading judgment, found great difficulty with the Court of Appeal's approach on this, which was found to be inconsistent with commercial reality and the accepted function of liquidated damages. It was set out within the judgment that the commercial reality of these contracts is that parties agree an LD clause to provide a remedy that's predictable and certain for a particular event, for example, delay. Lady Arden held that the parties must be taken to know the general law that liquidated damages come to an end on termination. Now, this is the important bit of the judgment in terms of common law implications and precedent. It was found that parties do not specifically have to provide for the effect of termination in respect of liquidated damages. They can take that consequence as read. So the effect is you don't need to provide for an LD clause coming to an end on termination. That is already automatically part of the contract. In short, the Supreme Court found that where there is a liquidated damages provision, which provides that it ceases on completion or acceptance of the works, this is in addition to, as opposed to substitution for, it ceasing on termination. Importantly, both Lady Arden and Lord Legate felt that this is the reading that met commercial common sense and prevented the unlikely elimination of accrued rights. So finally, what are the implications of the judgment on this issue? Now, I'm sure there are a lot of implications, but for today's purposes, I just note 4 conclusions. Firstly, a previous judgment cannot be binding as to the meaning and effect of a contractual clause unless that clause falls within a certain specified exception, namely a market-accepted wording or a standard form clause. Secondly, in circumstances of termination, liquidated damages clauses are presumed to apply up to the date of termination unless the clause specifically provides differently. Thirdly, when interpreting contracts, regard must be had to commercial common sense as opposed to necessarily focusing solely on the wording of a clause or the literal wording of a clause. And finally, throughout the judgment, the Supreme Court, and in particular Lady Arden and Lord Legate, signalled their very strong support for liquidated damages and the benefits for both parties. Now, this is something that's been touched on earlier in this webinar, and it is, I think, a bit of a departure from certain previous court opinion on the same, but it perhaps segues in with some of the cases in Magdesi and otherwise. But it does signal a support for these clauses, which may not previously have been the case. Now, this may have implications for the future interpretation of these clauses, and indeed technical arguments regarding the application of these clauses. So I think put it back to you, Paul. Thank you.
It's very kind. It's very kind indeed. A marvelous summary. You get the sense of the judgment when they deal with my argument that if there isn't acceptance, then there's nothing for the liquidated damages to be triggered by saying, well, you could just say date of acceptance means date of acceptance, comma, if any, comma. And that gives you the... But the important thing, and Alex has made the point very well, the important thing about this case is it makes liquidated damages the national treasure that I'm talking about. It very much, that they appear that liquidated damages clauses are very good things. Parties are deemed to know about them, and any suggestion that they don't work, the court starts with a healthy skepticism towards. Whereas the old cases would have been the other way around, because it's being thought that a contractor is being subjected to a specific liability. So I think it's a very, very interesting development. And the combination of the relaxation of the law on penalties, which, let's face it, is what Magdesi is, coupled with this is and of course, because of adjudication, fewer cases get into the courts nowadays on the technical points that used to be made about conditions precedent not being satisfied, the right certificates not being there. So that combination works together to make liquidated damages much safer and much less liable to attack than ever they were before. Thank you very much, Alex. That was it's always nice to recognise the case you've been in. So we're now going to turn, please, to Vivek Kapoor, who is another member of 39 Essex Chambers, who transferred from being a solicitor. It was a tough road. I joke, the reason it was a tough road that he was my pupil. I was his pupil supervisor. I thought that was all long behind me, but we had a marvelous time together, and I'm delighted that he's with us this morning to talk to us about the limitation of liability provisions that came out of Triple Point, which were also argued in that case in the Supreme Court. Vivek, over to you.
Thank you, Paul. In addition to the principal issue regarding liquidated damages, the Triple Point case also turned on the interpretation of a clause which placed a limitation upon the liability of the contractor, Triple Point. Now, caps on liability are commonly seen in energy, infrastructure, construction sectors. In construction, a total cap on liability is the best way to limit a contractor's exposure to liability under a contract. However, in most commercial contracts where there is a cap, the cap operates as a limitation on liability subject to exceptions, the application of which often becomes controversial between contracting parties. As Sir Rupert observed in his judgment in the Court of Appeal, we now move into territory where both parties are attacking the judge's decision. In the Court of Appeal, the operation of the liability cap was a ground of Appeal 6 and the ground for respondents cross-appeal. PTT said that the judge erred in applying the Article 12.3 cap to any part of the damages claim. Triple Point said the judge erred in failing to apply the Article 12.3 cap to all of the damages claim, including the liquidated damages for delay. In the Supreme Court, the analysis is given in the leading judgment delivered by Lady Arden. Now, both the Court of Appeal and the Supreme Court dissected Article 12.3 in 4 parts, essentially interpreting them as separate but related limbs forming this clause. Now, Article 12.3 of the software contract comprised 4 sentences. The 4 sentences, in essence, provided, first, Triple Point was liable to pay the damages suffered by PTT arising from its breach of contract. Express reference to software defects and contractual functionality requirements were made here. Second, Triple Point's total liability to PTT under contract was capped at the contract price received by TPP under the contract. This is what is sometimes called the global cap. Third, except for specific remedies expressly identified elsewhere in the contract, PTT's only remedy for claims under the contract was for Triple Point to use best endeavors to cure the breach, or failing that, for Triple Point to return the fees it received for the services or deliverables related to the breach. This is the limitation on the form of remedy. And finally, fourth, liability resulting from fraud, negligence, gross negligence, or willful misconduct was carved out from the limitation of liability. This was the cap carve-out. As a result, 2 related issues came before the Supreme Court. These were, first, whether an exception from the cap in Article 12.3 for negligence removed from the cap losses by Triple Point's negligent breach of contract, or only losses for the commission of an independent or freestanding tort. And second, whether liquidated damages payable by Triple Point were capped under Article 12.3. Now, in the first instance, the judge had held that Triple Point's liability in respect to wasted costs and termination loss was capped by the amount paid by PTT under the contract prior to termination. However, PTT's entitlement to liquidated damages was not subject to the liability cap. The Court of Appeal held that the carve-out for negligence applied only to cases of freestanding tort or deliberate wrongdoing. It did not capture Triple Point's breach of express contractual obligations to exercise reasonable care and skill. The reasoning behind this conclusion was that given the centerpiece of the contract was a provision of services, the cap would be rendered useless if the breaches of the contractual duty of care were carved out. Then the Court of Appeal went on to hold that Triple Point's liability to pay liquidated damages was subject to the cap in Article 12.3, together with all other entitlements to general damages. At the Supreme Court, Lady Arden disagreed with the Court of Appeal in that, in her judgment, liquidated damages fell within the cap carve-out as the result from a negligent breach of Triple Point's contractual obligation to use reasonable care and skill. Now, before I discuss this in a little detail, I should end the suspense, if there was any. Subject to this carve-out for negligence, the Supreme Court agreed that liquidated damages fell within the global cap and were to count towards the maximum damages recoverable under this cap. Now, returning to the carve-out for the negligence issue, Lady Arden pointed out that the concept of negligence generally has an accepted meaning, which covers both the freestanding tort of failing to use reasonable care and also a party's breach of contract to exercise the contractually required standard of care. However, looking at the specific clause in question, she found it unlikely that the parties contemplated that only tortious breaches were to be captured by the carve-out. Article 12.3 makes repeated references to contractual liabilities. She commented further that the Court of Appeal overlooked or put too little consideration on the fact that Triple Point's obligation not only was to provide services carefully, but also to provide defect-free software and contractual deliverables with an agreed level of functionality. On the facts of this case, Lady Arden held that the provision of the defect-free deliverables to agreed level of functionality fell within the compliance of specific contractual terms expressly referenced in the first sentence of 12.3, and the said provision did not fall under the remit of contractual obligations to use reasonable care and skill. Excluding liability for negligent breach of the contract from the cap carve-out actually would not render the cap useless, because the provisions of services with due care and skill was not the core obligation of the under the contract. Now, Lady Arden completely reversed the Court of Appeal's finding on this point. She held that the cap carve-out for negligence included breaches of contractual duty of care, but excluded independent torts. This meant that liability arising from negligent breaches of contractual duty of care were not subject to the liability cap. I should point out that the justices of the Supreme Court were divided on the interpretation of negligence under 12.3. Lord Leggett and Lord Burroughs concurred with Lady Arden. Lord Leggett found that by accepting that negligence meant the freestanding tort of negligence, the Court of Appeal could build into the word a convoluted meaning which would not reasonably bear. On the other hand, Lord Sales, who agreed with Lord Hodge, agreed that the Court of Appeal's interpretation that Triple Point's core obligation under the contract was to exercise reasonable care and skill. And accordingly, 12.3 should be interpreted in a way that allowed Triple Point to be protected in respect of ordinary breaches of this core performance. Now, on the capping of the liquidated damages issue, the Supreme Court agreed with the Court of Appeal. The court looked specifically at third sentence of Article 12.3 and considered it in the context of the provisions of the contract. Unlike defects, delays are not something which can be cured by the contractor. Accordingly, there were specific provision elsewhere in the contract to value delays, and liquidated damages as remedies for delays was also provided. Now, the third sentence of 12.3, therefore, was meant to deal with breaches not involving delays. Lady Arden held that the second sentence, which was the global cap, and the third sentence, which was the limitation in the form of remedy, served separate functions. One did not qualify the other. In this case, the limitation in the form of remedy should not be written into the global cap. This meant that liquidated damages fell under the global cap so that they counted towards the maximum damages recoverable by PTT under the second sentence of 12.3. Now, the key takeaways for me is, I think Triple Point is a reminder that clear words are necessary before the court will conclude that the contract has taken away valuable rights or remedies which one of the parties to it would have had. Now, the assumption is that parties normally do not give up valuable rights without making it clear that they intend to do so. So I think the guidance from this judgment is exceptions and carve-outs which are realistic, well-defined, and in accordance with the commercial sense are more likely to be held by the courts. In their judgments, before I conclude, I should say that The Supreme Court and the Court of Appeal looked at the substance of the transaction and the contract while interpreting the clauses in dispute rather than simply applying business common sense. However, this is an area of law to be looked at because there is likely to be more development considering the different views of the justices. And Paul, with that, I will hand it back to you.
Thank you, Vivek. The negligence one, very interesting because Triple Point managed to persuade 6 judges. The first instance judge, Mrs. Justice Jefford, the whole of the Court of Appeal, and 2 of the Supreme Court. So they managed to persuade 6 they were right and failed to persuade there were three, and were still wrong. I think your point is that, which I would respectfully completely agree with, is that you seeing the courts being very cautious about removing rights, which I think is a bit. There's ebb and flow in all of these cases, and one of the great skills in this job is predicting which way they're going to go. But the ebb and flow, I think, was the common sense approach to construction. Simple look at the words, what the party's intending, which has grown in and removed all the old principles like the marvelous principle of contra proferentem, which you can't even mention now, let alone rely upon. And I think that these sort of cases are spikes back, as it were, to say, you know, we may interpret these contracts by simply looking at the language, but we've got to remember that, you know, you do need a certain amount of clarity to remove rights that would otherwise be there. So I think that's, with respect, I completely agree with your takeaway.
This decision reflects the sort of modern view of contractual interpretation that commercial parties are free to make their own bargains and allocate risks as they see fit. And the task of the court is to interpret the words fairly by applying the ordinary methods of contractual interpretation.
Yeah. Well, thank you very much indeed for that. I'm going to then come on finally to David Hopkins, who is going to pick up a liquidated damages theme and consider when the liquidated damages clause limits the contractor's liability, does it limit it where it's been found to be void and inoperable? And he's going to look at the Echo World case that we've heard referred to before. I myself think that this is a very important area now because what happens if liquidated damages are, for whatever reason, not capable of being recovered for a category of different reasons, then I'd be interested to see whether the court adopts the same sort of helpful approach to the parties that it has in relation to the underlying question. So, David, over to you.
Paul, thanks very much. Good morning, good afternoon, good evening to everyone. I thought Nick had torpedoed the relevance of my talk below the waterline when he said that it's unlikely that any clauses were going to be found to be void as penalties following McDessie. But I was very glad he then went on to say that, in fact, there was a 2021 case in which such a clause has been found to be void. And as Ruth said, these arguments will still be popular, so you can still run them even if you might not win. And then finally, Paul mentioned earlier about the fact that liquidated damages clauses may well operate for the benefit of a contractor. And this very much is an area where that is relevant. So everyone, I think, here will be generally comfortable with the fact that if the liquidated damages clause is void, the employer can nevertheless sue for general damages. And that was the Rapid Annealing case in which Richard Wilmot Smith acted in the 80s. Everyone's also generally comfortable that if the employer sues for general damages in that situation, then the liquidated damages clause will act as a cap on those damages, and the employer won't be able to recover more than that. And as is common with these types of things, where everyone's generally comfortable with it, you might occasionally think, oh, I better check that. And if we did want to check the position, we might turn to the best textbook on construction law, Wilmot Smith and Construction Contracts, published this May 2021. And at paragraph 11.16, we would find it says, the textbooks which discuss it all agree that the employer cannot recover damages at a greater rate than the liquidated damages allowed for in the contract. And so we'd all turn back and say, fantastic, thanks, that's sorted. But as it says, to be fair to the textbook and the other textbooks which discuss it, as it says in those books, the point actually hasn't been decided by any authority. And indeed, the understanding that a liquidated damages clause would act as a cap on general damages wasn't shared, perhaps, in other areas of law in analogous provisions. Especially, this is the case in shipping, where there's a line of charter party cases which have held that an innocent party can ignore a penalty clause and sue for its actual loss, even where that clause says something along the lines of the penalty shall be no more than the value of the freight, and so on. So that question was left open. And as Wilmot Smith goes on to say, nonetheless, it might be a surprisingly bold employer which argues that its provision for liquidated damages is a penalty and seeks to recover a greater sum. So far, this has not been attempted. And so that was a question very much looking for a bold hero or villain to take to the court. And indeed, we got one in the shape of EcoWorld Ballymore. EcoWorld Ballymore being the employer at the Embassy Gardens site in southwest London. And in the case, which came before Mrs. Justice O'Farrell in July, I think, and then her judgment was handed down in August, the employer, EcoWorld Ballymore, took the position that its own liquidated damages, the liquidated damages clause in the provision was void and unenforceable, and it should be entitled to claim general damages for delay, including any damages above the level stipulated in the contract. Funnily enough, that was the opposite of the position it had taken in adjudication. When in adjudication, it was Dobler, the facade contractor, who argued that the provision was void, the LD's clause. Once it got to court, however, it seems that EcoWorld Ballymore suddenly realised there might be quite a nice angle to argue here, and it potentially could recover more than what was stipulated for as liquidated damages. I'll give you briefly the contractual background. This was a JCT 2011 construction management trade contract. And Dobler, as I said, was a facade contractor who'd been contracted to design, supply and install the facade and glazing works at a building, which was in 3 blocks, A, B and C. However, there weren't any provisions in the contract for completion and sections. But nevertheless, there was the contractual right for the employer to take early possession. The completion date was 30th of April 2018. And of course, the works were incomplete at the completion date, otherwise there'd be nothing to talk about. And 6 weeks later, the employer, EcoWorld Ballymore, exercised its contractual right to take possession of blocks B and C, but it didn't certify practical completion in respect of those blocks. The works were eventually complete in all 3 blocks by 20th of December, so around about 8 months after the completion date. Now, the liquidated damages clause in the contract stated that after the first 4 weeks in which there would be no liquidated damages, the LDs would be £25,000 per week or pro rata for part of a week, up to an aggregate maximum of 7% of the contract price. And as I mentioned, there weren't any provisions that broke that down into sections. So at adjudication, Dobler argued it was void for uncertainty, or it was a penalty, because once blocks B and C had been taken over by the employer, then practical completion was deemed in respect of those blocks. And since the LDs clause didn't make provision for splitting up the LDs or dividing down that £25,000 per week, it was a penalty, or it was uncertain. Now, as I say, in the end, it was the employer who decided to take this argument on the Part 8 claim for declarations as to the true construction of the clause. And in the judgment, Mr. Justice O'Farrell, in fact, held that the clause wasn't void, very much running along the theme that we've talked about already today, that the courts will seek to uphold these types of clauses. But helpfully, what she did do was to provide a obiter judgment on the position if the clause had been held to be void. And that's pretty much the first detailed consideration of this question by the courts, albeit obiter. Counsel for the employer went straight to McDessie and said, McDessie says, if you find the clause is a penalty clause, it's wholly unenforceable. So this can't be of any effect and therefore shouldn't cap my damages. Mrs. Justice O'Farrell took a slightly more nuanced approach and said, it doesn't follow from Negligence that such a provision will have no contractual effect at all, even where the LD's clause is found to be wholly unenforceable as a penalty. It may, on its true construction, be found to operate as a limitation of liability. And those of you with good memories will remember that when I quoted the LD's clause to you, at the very end of it, it says up to an aggregate maximum of 7% of the contract price. And that, I think, my reading of the judgment was very much at the forefront of Mrs. Justice O'Farrell's reasoning. She said the objective understanding of the parties in the commercial context of the contract would be that the provision served two purposes. First, to provide for and quantify automatic liability for damages in the event of delay. That's the £25,000 per week. And second, to limit Dobler's overall liability for late completion to a specific percentage of the final contract sum. And so for that reason, she said, even if this clause had been void, what it was doing was serving as a limitation clause, limiting Dobler's liability to 7%. And as a result, any general damages would be limited to that amount as well. So what are the takeaways? As I mentioned, this is an overture judgment, but it is the first judgment to deal with it in any detail. And it's Mrs. Justice O'Farrell, obviously an experienced TCC judge with a construction background. So it's certainly likely to be followed, I would suggest, if a case comes up with similar facts and contractual provisions. But it doesn't have to be, of course. Assuming it is followed, the takeaway is that a void liquidated damages clause can be a cap on general damages, but only if, on its true construction, it also serves to limit the contractor's overall liability for delay. What's interesting is that suggests a void liquidated damages clause, which doesn't limit liability on its true construction, would not be a cap, and the employer could sue for unlimited damages. And that's actually moving the position beyond, as I say, what's in the textbooks. Unfortunately, all those textbooks were printed before 3rd of August, of course. So finally, the takeaway is check your liquidated damages clauses. Clearly, a contractor entering into any new contract or who is potentially currently in delay will want to make sure that its liquidated damages clause limits liability as well as stipulating the amounts of liquidated damages. The employer may well want to do the opposite. And with that, thank you very much. And back to Paul.
Thank you very much indeed. I think it's very interesting that if one looks at the range of authorities over the last 100 years, one can see many, many different routes to inoperability, whether it's penalty, or whether it's time at large because of an act of prevention that isn't covered by the extension of time clause, or whether it's some deficiency in the operation of the clause, wrong certificates or time expired or conditions precedent. Each of those is obviously going to be different. And I think that the Mrs. Justice O'Farrell's approach is very helpful, because what she essentially says, it's helpful but unhelpful. What she essentially says, it's a question of construction. As Lord Justice Coulson was once heard to say, my advice is go and see a lawyer. That for me is this is a really fascinating area. And it's one of the areas where I think that we are seeing the effect of adjudication on the lack of development of the common law and construction of contracts, because these are the sorts of points that before adjudication were troubling the courts regularly, and they trouble the courts less regularly now because of the way our dispute resolution system has developed. And I think you're right that Mrs. Justice O'Farrell, who is, she's the presiding judge of the TCC, she has a very high reputation. She's been a construction practitioner throughout her entire career. I'm not saying that what she'll say is taken as gospel, but if you look at the balance of the construction judiciary, they're certainly going to start with showing great respect to that decision. Do any of the rest of my panelists want to come in on the topic about liquidated damages, or bearing in mind how time is going, and of course, Nicholas Higgs having departed, I'm determined to apply his incentivization methods to the timing of the end of this seminar. So it will finish before 10:29 will be the latest time that it will finish, because I want to be able to tell him that I was incentivized for early completion. But Philippe, do you want to add anything to what David's just said? Liquidated damages, do you have the sense do you share the sense that the courts are very keen and enthusiastic about them, or are those of us who've just been burnt in the cases feeling a little bit weak about it? What do you think?
I think, where they're clear and certain, they will be upheld. And really, I found Vivek's segment on the negligence issue quite interesting, because if at Supreme Court level, that's the level of granular detail that is still sort of open to argument, shows that a more typical liquidated damages provision, simply setting out payments and time periods to which it relates and clearly setting the trigger events, you'll have a very tough time to take that all the way to trial as an effort to delay or find a way to free up some cash flow before you are hit with a judgment. And I think, as you were saying, Paul, because of the shift to adjudication, actually a lot of these cases, including Magdesi, are not construction cases, and even Triple Point is more of a software supply case.
Definitely.
So that's even in more general commercial contracts, you see the same trend in upholding them and not interfering unless really required to.
Yes. Vivek, how do you see it with your different perspective?
I couldn't agree more, and I think what all the other panelists have said is absolutely correct. I think that there's nothing more to add to that.
Yeah. Well, you've got 4 minutes, so you can add a bit more. Alex, you looked at Triple Point. What's your sense of the mood of the courts? Am I right, or am I being lily-livered about it?
No. I think you're right. You can see in the.
That's a good start. Good start.
You can see. You can see within the judgment, within certain paragraphs there, the language that's used by Lady Anne and Lord Leggett, and the way in which they are discussing these clauses. I think, for example, we've got paragraph 74 of the judgment saying each party is therefore better able to manage the risk, and talking about the benefits of these clauses for both parties, and how they are such a standard feature of the construction industry. They really gives an impression of their sort of the value that they hold these clauses in these days. So, and you can see it in the cases that we've discussed. You can see it in certainly in the English courts in relation to, for example, the condition notification condition precedent point, which is a slightly separate issue, but again,
same approach.
Yeah, a way of preserving liquidated damages when there are attacks on it. It does seem to be going that way, and certainly the wording of that judgment supports the court's attitude towards them that we seem to be disseminating.
And Ruth, does that fit with the approach that you've identified in your bits?
Yeah, so I think absolutely looking at them. I mean, it's interesting when we hear about Mrs. Justice O'Farrell's judgment in Eco World, and I thought that David's observation that different arguments are run in adjudication versus when you get for the TCC is interesting. I think that shows two things. One is that oftentimes there are huge commercial interests behind these clauses, and they can actually be used for either party, depending. A party mightn't even realise they have a benefit that they've signed up to. But I think what's also interesting comparing that TCC judgment with the Supreme Court is that the TCC, a specialised court, are well adept to dealing with assessing liquidated damages where they have to. But as you get further up that ladder, up to the Court of Appeal, Supreme Court, those appellate courts in particular are very mindful that they probably aren't in the best position to assess what can be quite complicated calculations in terms of very specialist areas. So I'd certainly agree with what all the panelists have said. I think certainty is the aim of the day in terms of these clauses now.
David, can I give you the final word before we comply with the Higgs incentivization principle?
Well, it was going to be exactly on that. I'm very interested in what Nick was talking about in terms of possibly restructuring a liquidated damages provision instead as a bonus provision for early completion, which would have exactly the same economic effect, but perhaps be more amenable to the courts. Seems to me you could write a contract which said you've got 20 years to complete, but you'll be given a bonus of £25,000 per week for every week you complete early, and the contract sum is nil. So that effectively it was a liquidated damages provision, and the earliest completion date perhaps is 1 year's time. So I'd be very interested to see what happens if that ever comes before the courts, and if anyone's got anything like that which they want some advice on, or is looking to move to litigation, please do send it my way.
I can tell you, just as we finished, that in Temlock and Errol, the evidence was irrelevant evidence, but I got it out by accident, that the contractor was not going to be liable for liquidated damages, provided he wasn't late. That they hadn't thought it through, but they had this mutuality of no loss and expense, no liquidated damages. And I think these commercial transactions, do provide solutions to some of the problems. And we can all go on as lawyers serving our clients by construing the contracts that they've made. And let's face it, in this area, clients have done the lawyers a great deal of favors over the years, and it looks as though the giving may have come not to an end, but certainly slowed down for a combination of reasons. With that, can I thank you all very much indeed for listening to us. We've enjoyed presenting to you. I hope you found it interesting and helpful. We'll look at the questions afterwards to make sure we pick them all up. And can I wish you all a very good day. Good morning, good afternoon, and good evening.